Imagine a world where love leads not only to companionship but to the loss of legal identity, where the moment a woman said, "I do," she vanished, at least in the eyes of the law. This isn't dystopian fiction. This was reality for millions of women across centuries. From the bustling streets of 18th century London to the quiet towns of Puritan New England, married women lived under a legal doctrine known as coverture, a term that meant, quite literally, that a woman was covered by her husband's legal identity. Before marriage, a woman had rights. She could own property. She could sue and be sued. She could enter into contracts. She might be restricted by custom, by social class, by religion, but legally, she was a person. After marriage, that changed. The law treated husband and wife as one person, and that person was the husband. Let's unravel this story from the beginning. In medieval England, coverture was already taking root. Influenced by Norman law and church doctrine, English common law began to codify the idea that a husband and wife were a single legal entity. But it was a unity with a twist. Only the husband had rights within that entity. The wife's separate legal existence was suspended. Blackstone, the famous 18th century legal commentator, wrote, "By marriage, the husband and wife are one person in law, that is, the very being or legal existence of the woman is suspended during the marriage." He meant that quite literally. A married woman couldn't own property, not even if she inherited it. It became her husband's. She couldn't control her own earnings. She couldn't sign a contract or take out a loan. She couldn't testify in court without her husband's permission. She couldn't even write a will without his approval. And yet, unmarried women could. This is one of the most fascinating legal ironies in history. An adult, unmarried woman, whether a widow, a spinster, or simply someone who never married, retained all her legal rights. She could run a business, own land, invest money, even serve as a guardian or trustee. In some cases, she could wield more economic power than many married men. Marriage, in the eyes of the law, was a kind of civil death for women. Let's look at some real cases. In colonial America, widows often ran taverns, farms, or trading businesses. They managed money, signed contracts, even took people to court. But if they remarried, all those powers vanished. One day, they were heads of households. The next, they were legal non-entities. In France, under the Napoleonic Code, the law was even more explicit. Article 213 gave the husband absolute authority over his wife. She needed his permission to work, to travel, even to open a bank account. This law remained in effect well into the 20th century. Even in Scandinavia, often praised for gender progressivism, married women were legally subservient. In Sweden, married women were legally minors under their husband's guardianship until 1921. But here's where it gets even more curious. Despite their lack of rights, married women were still held legally accountable in selective ways. For instance, if a married woman committed a crime, say, theft or assault, she could be prosecuted. But in contract law, she was considered incapable of intent, so she could steal and be punished for it, but not buy and sell property. Convenient for the legal system, wasn't it? There were exceptions, of course. In some towns and cities, customary law gave women more rights. In parts of Germany, under the system of Handelsvollmacht, wives could be given limited power to act as their husband's agents in business. In Hanseatic cities, widows often inherited commercial enterprises and were legally permitted to manage them. In Islamic law, married women retained the right to own property and manage their finances independently. They could even sue their husbands. This stood in stark contrast to European models, although interpretations varied across regions. And in ancient Egypt, women had remarkable legal independence. They could own land, represent themselves in court, and initiate divorce. It would take Western civilization thousands of years to catch up. So why did Europe move toward such a restrictive model? It was partly religious. The Christian doctrine of headship gave husbands spiritual and moral authority over their wives. It was partly economic, keeping women out of the marketplace preserved male labor monopolies. And it was partly political. Subordinating women helped preserve traditional hierarchies of power. What's even more surprising is how late these laws remained. In Britain, the Married Women's Property Act wasn't passed until 1870, and even then, it was limited. A married woman could now keep earnings she made after the act was passed, but not property acquired before. Full property rights for married women wouldn't arrive until 1882. In the United States, progress was piecemeal. Some states began reforming marital property laws in the mid-19th century, but others lagged behind. Mississippi, ironically, was the first state to grant married women property rights in 1839 thanks in part to a campaign led by a plantation owner's daughter. But many southern states resisted, fearing that giving wives rights would undermine male authority. And what about the courts? Even when laws changed, courtrooms didn't always follow. Judges, trained under centuries of patriarchal tradition, often interpreted laws narrowly, reinforcing the status quo. A married woman might technically have the right to sue, but practically, she'd need a husband willing to let her do so. In practice, many women found creative ways around these restrictions. Some set up trusts before marriage, placing assets in the hands of male relatives or lawyers who would manage the property for their benefit. Others used false names or middlemen to conduct business. A few took their cases to court and won groundbreaking victories, like Caroline Norton in England, whose activism helped reform British custody and divorce law. But for most women, the system remained stacked against them. And yet they persisted. They opened schools. They wrote books. They organized. They lobbied. They protested. In the suffrage movement, women not only demanded the right to vote, they demanded legal identity, to be seen by the law, to be counted. The story of married women's legal dependence is not just a story about gender. It's a story about power, about who the law recognizes as fully human, and about how easy it is for rights to vanish, not because of war or revolution, but because of tradition. Today, the legal status of women has transformed dramatically in many countries. Married women can open bank accounts, sign contracts, start businesses, and testify in court. But in some places, remnants of coverture remain. From tax codes to immigration law, marriage can still create legal entanglements that affect women's autonomy. Understanding this history isn't just about looking back, it's about knowing what was fought for and what remains fragile. Because the law remembers, and we should, too.